Violations. So there are several violations that we still see on a regular basis. If this is you, I apologize. No company names have been used. I think we've scrubbed it so that the innocent might be protected, or the guilty. All right, so here are a few of our most common violations. Physical location. So we still are having this. We have a statutory section that provides that a physical place of business needs to be within our state. Each branch office of the MLOC shall be identified in NMLS to consumers as a location where the licensee holds itself out as a mortgage loan originator company. So this could be someone's house. We are one of the few states that allow for home offices. You just need to make sure that when we do our exam that your house is actually open for us to go and view, make sure that your files are kept safe. You know, you have a place for consumers to interact with you. All right, so here's the violation that this company ran into. The company provided photos of a commercial location that did not describe or resemble the description of the Hawaii location. And how did we know that? They sent the photos, we went out to look, didn't look anything like that. The company admitted that the photos were not in Hawaii. And the company did not have a sign showing business hours, nor did they have business hours posted on their website. So that was a violation. So, you know, if you are unlucky enough to try to say that you have a physical location and send us pictures, and we go out there and your location doesn't look anything like your pictures, that could be a problem. This one is a really common one. The record retention in Hawaii is 7 years. So here's what the company did. The company indicated that the company's retention period for open and closed loan files is 4 years, and 2 years for denied, canceled, and rescinded loan application. So this particular company did not even follow federal law. The retention period under federal law for closed loans is 5 years. And the retention period for denied, canceled, and rescinded loans is 2 years. But they forgot that in Hawaii, we have a longer retention period, 7 years. You can hold those electronically, that's fine, as long as we can get access to them if we did an examination. So the correct answer when we ask you for the record retention is not that somebody else is holding all of our records and that company went out of business, so we don't have any records. Okay, that's going to be a clear violation of this particular law. Your responsibility as an MLOC is to have access to those records. So if you're using a third-party provider, please make sure that you have in your contract that you will be able to access those records if that third-party provider is no longer in business. Oops. Here's a common violation, and this is where we make all of our fees. This is what pays for all of the staff that you see today. The requirements for filing the mortgage call reports is 45 days after the end of every calendar quarter, and a financial report is due within 90 days of the company's fiscal year. So we send out, and NMLS will send you emails letting you know that you missed the deadline. So when that ends up in your spam mail or your junk mail, I'm going to tell you that that's not our problem. You've already violated our law. So NMLS will send out the first email letting you know that you missed a deadline. We generally will follow up a couple days later and say that you missed a deadline. You now have a license item on your license. And that becomes pretty critical at the end of the year at renewals. If you have a license item on your license, you will not be able to renew your license. In fact, I think you can't even apply for the renewal of your license. So best to clear all those up. We do send reminders out to let you know that if you have a license item on your record or your company record, you need to clear those up so that you can participate in renewal if you want to renew your license. Okay, so here's what the company did. The company was required to file its 2017 financial condition by March 31, 2018. On April 1, the company was sent a notice that the financial component requirement was not filed, or the financial condition was not filed. On April 4th, the company filed its financial component 4 days after the report was due. So those of you who have been in this, you know that we've fined you for these 4 days of the late filing. And as I said, jokingly, but we get a lot of fees, or we get a lot of administrative fines from this particular violation, and it seems to be an easy one for you folks to comply with. So, just kind of calendar that in advance. Do not start trying to figure out how to fill out the mortgage call report a day before it's due. It's too late by then, because too many things could happen. We've heard all the excuses. My computer broke, the website is down, NMLS is closed. Whatever it is, we've heard it. No excuse. Start early. All right. The next one, common exam violations, mortgage foreclosure. Okay, this is a unique law in Hawaii that requires that a notice be given to all borrowers that foreclosures could happen to them. So this notice shall be provided to all applicants and all owners of residential property within 3 business days after the submission of a loan application. So what we suggest to everyone is to just put this in your opening packet. It's one piece of paper, just include it as part of your loan packet. So here's the violation. 3 of 10 originated or closed loan transactions, the company did not provide the Hawaii mortgage foreclosure public information to the applicant. So unfortunately, this is not one that you can correct. You can't now, after we found the violation, send it to the customer. It's already too late. You can't fix it. So whoever you sold that loan to might have a problem if the borrower starts defaulting, foreclosure process ensues, they will not be able to complete it. So don't forget. And I'm not sure if that will mean that you might have to buy back that loan from your investor. That's a possibility. So just know that you cannot fix this one. Here's another one, privacy laws. So here's one that there's actually a model privacy form within the statute. So information required in the model privacy form includes general instructions for the disclosure table and specific disclosures and corresponding legal provisions. So there's already a form, I'm sure you've all seen it, what it looks like. And all you have to do is fill it out. Fill it out once, correctly, and you can keep using it. Okay, so here was the violation. The company issued different privacy notices depending on which MLO processed the loan. Examiners identified that in some instances, the company issued the self-created privacy policy notice, which is okay as long as you hit all the components of the federal law. In other instances, the company issued the model privacy form, but left all of the sections blank, so they just printed out the blank privacy form. So, not quite compliant. This one you can fix by sending your borrower the correct privacy form. All right, Reg Z, the Truth in Lending Act. I think I have a couple of examples here. And this is typically what happens. The consumer locks the interest rate, let's say on October 15, 2017. The company then issues a revised LE dated October 18 that disclosed 0 points with an interest rate lock expiration of November 13. On November 1, the company issues a revised LE due to interest rate pricing disclosing a 1% loan origination fee. However, the change in interest rate pricing is not a change in circumstance because the interest rate lock did not expire. So I don't know how many of you have done this, but we see this a lot. Interest rates are moving, you want to continuously send out the interest or the LEs to your consumers. In this case, we ordered the company to pay back the customer $11,579.93. So that was a lot of money, which was the actual loan points erroneously charged to the consumer. That was just one loan. We made the company go back and scrub through all of its loans to see if they had any other violations like this. And if they did, and they did, they had to provide restitution to those customers. So this could be an expensive violation for you. Next one, Loan B. The customer locked an interest rate on January 27. The company then issued an LE on the same day that disclosed lender's credits of $506 with an lock expiration date of March 11. The company reduced the lender credits on the closing disclosures dated 3/10, 3/11, and 3/14. I'm not sure why there were so many. The company did not provide an explanation for the revised LE to show us what the valid change in circumstance was. So, here was a violation. The lender credits of $505 originally disclosed on January 27 should have been honored at loan closing. The company was ordered to refund $108 to the consumer. So this is just simple math that we do. You can see how it kind of adds up. The bigger penalty, of course, is we make the company go back and scrub through all of its files to see if they've done this before, and if they have, they need to refund or provide restitution to all of those customers. Also, a potentially expensive finding. Oh, and I should say, we leave it up to you folks to try to scrub your files. Send us a letter saying that you scrubbed all your files, that either no other files look like this, or you provided restitution and give us a list. The next time we come out for an examination on your company, we're going to check to make sure that that was actually done. So make sure you don't falsify that particular document, because that would be a bigger violation. All right, next one, Reg Z. Good faith determination for estimates of closing costs. Okay, so these provisions provide that estimated closing costs on the loan estimate, the LE, is in good faith if the charge paid by or imposed on the consumer does not exceed the amount originally disclosed. All right, here's the violation. The examiners reviewed 10 residential mortgage loans and identified 4 where the company did not list the homeowners association charges under closing cost details. So I don't know how many of you are actually doing condo loans or residential mortgages in a homeowners association. Don't forget to include those in the right place. So in this case, the company erroneously listed the homeowners association under closing cost details, services that you can shop for on loan estimates. So let me ask you, do you think you can shop for these homeowner association fees? Okay, so you're right, whoever said no, you cannot shop for these. Unless, of course, it's you're buying a brand new house, in which case you can kind of not buy that one. But generally, no, you cannot shop for these. So be sure to put that in the right place and be sure to list it. Okay, here's another one. Content of the disclosures. So a lot of these statutes now have model forms. Don't just print out the model form and give it to the customer blank. That's not what that means. It means that you need to fill it out properly. Okay, so under this section, under the subheading Other, an itemization of any other amounts in connection with the transaction that the consumer is likely to pay or has contracted with a person other than the creditor to pay at closing. There are official interpretations to this particular law that provides examples of what these other items that need to be disclosed look like. Then the next section also requires a creditor to notify an applicant of the action taken within 30 days of receiving a completed application or 30 days after taking adverse action. So here, the customer found, or the examiners found 3 of 10 canceled, withdrawn, or rescinded files that exceeded the 30-day notification requirement. So right, this is not like 30 calendar days. It's 30 days after there's no contact with your customer, or, after that the customer either withdrew the application or told you that they want to withdraw the application, or somehow indicated to you that they don't want to go forward with the loan. That's when the clock starts. So this is an easy one to calculate. You can put it in your calendar if you wanted to just mark off when those 30 days would occur. Another ECOA violation. ECOA prohibits creditors from discriminating against credit applications based on the basis of race, color, religion, national origin, sex, marital status, age. And age is providing that the applicant has the capacity to enter into a binding contract. So if your customer is 10 years old, they might not meet the age requirement. If they're 65, they might meet that age requirement. All right, and within that disclosure, it lists the name and address of the federal agency that should be listed on that notice. So here's a violation. In 10 of 10 originated and closed loans that the examiners reviewed, the company incorrectly disclosed the wrong office of the federal agency. So here's my big clue for you today. Go back, look at this notice that you have. The correct federal agency is the Federal Trade Commission, Equal Credit Opportunity in Washington, D.C. So go back and check this. Easy to correct. You can send out another disclosure to the consumers. just in case they wanted to file a complaint. And they now know where to file it. So in this case, because there were 10 of 10 violations, what do you think we did? We went back, told the the company to scrub through its files, send everybody a new notice, correct their old notice, and send everybody the corrected notice. Now, what we don't know is how consumers are acting when they're getting these corrected notices. All right. And this is our second break. Are there questions before I add one more thing on any of these? Yes?
Yeah, mortgage brokers. So a lot of times our lenders do those disclosures, you know,
The early disclosures?
the LE and all these. And you specifically mentioned the one where with the privacy. So if they do that correctly, are we covered?
Yeah, so you want to make sure, so the question is, on the privacy notice, if you have a third-party vendor, say a lender, providing all of those LE disclosures for you, if they do it correctly, will that cover you? Is that what you're?
Correct.
Yes, so that should cover you. You want to make sure that you review what your third-party contracts look like, those vendors look like, because we don't go after the third-party vendor. The violations are to your company, not to the third-party vendor. If there's any restitution that needs to be made because of a mistake that your third-party vendor did, our expectation is that you, the mortgage loan originator company, makes the correction, and maybe your contract with the third-party vendor will allow for some reimbursement, maybe it doesn't. That's all on you. So it's up to you to manage that third-party vendor, make sure that they have the right disclosures. So we see that a lot, actually, that the third-party vendors are not providing the correct Hawaii disclosures. So every once in a while, I suggest that you might want to look at what disclosures are being pumped out by your third-party lenders that you're brokering to make sure that they are doing the right thing. Because if they're not, again, the mortgage loan originator company is the one with the violation. But you can use a third-party vendor to, provide all of those disclosures. Any other questions? Now that I just scared everyone. Other questions? Yes.
On the lender credit, if they do a COC on the LE before they do the CD, and would that avoid a violation?
So,
in your example, you would say they have the LE and then they do the CD, right?
mm-hmm.
Then if they did the LE with the change of circumstances, for whatever reason, and then they do the CD, would that avoid a violation?
So the question is how to avoid a violation if you do the change of circumstances on the LE before the closing disclosure, right? Okay, so you can do that. The change of circumstance, a little bit tricky. You want to make sure that you meet the requirements of what is a change of circumstance. A lot of times, you made a mistake on the LE, that's not a change in circumstance. Or maybe you've changed vendor for some reason. That's not really a change of circumstance either. So you want to make sure that you hit those requirements for the change of circumstance so that you can explain why you're sending out an LE, not just to us, but to your customer who might be asking why I'm getting another one. Because as I said, if not, the penalty is really reimbursing or sending a reimbursement to the customer of that difference and scrubbing through all of your files to make sure that you haven't done that before. So it could be really expensive. Other questions? Okay, so here's one more hint about all of these exam findings. So you know we use NMLS, and NMLS is a nationwide multi-state licensing system, meaning that all of the states are on it. If you work for a big company, if you work for a big company or even a small company that operates in a couple of states, the states are sharing this information. So we can share these exam reports with the other states in which you do business. So if we find a violation in one of these, what could happen is that the other states that you do business in could also open up an exam and see if you've done the same type of violation in their state. Because these federal statutes, if you violate them, they apply to all states. The unique Hawaii-only laws, they probably ignore because that's only for Hawaii. But what that could indicate to them is that you are also violating their state-specific laws. So just be sure when we have some of these violations, we do share this information with our sister states, and that could open you up for other examinations. Maybe not you, but your other sister company branches. And I would say in some states, some of the states are much more aggressive in their examinations than we are. I don't know if you know, but in some states, they don't have to send you an opening letter like we do. So we send you an opening letter saying, okay, in 6 weeks, we're going to be at your shop, we're going to do an exam, here's what we're going to look at. There are more than a few states that they can just walk in, say that they're doing an exam, and start conducting the exam. So just be sure you know that. We don't do that. We could though, but we don't. All right, so any questions about sharing information? Yes?
What are you guys charging out per hour as far as your examinations? Just curious. Or is it just a flat fee?
Okay, so the question is, how much do we charge for our exams? It's $60 an hour per examiner. We typically send 2 examiners for 1 week. And we're also doing off-site examinations, which are a little bit less expensive. So, we don't actually have to come on your site. We might stop in just for a visit to make sure, like one of the other violations for the photo, if you send us a photo. We just want to make sure that, you really have a location in Hawaii. Or in years past, where they send a photo of something that is a location, just not your location. So if you send us a picture of your mailbox, that's not good enough. So $60 an hour per examiner. And if the exam has to extend for whatever reason, that's an additional charge.
So it would be, so basically 60 times 2 is 120 times 40. And that's
Yes.
the budgeted for the
Right.
whole examination.
So we do that on a per exam basis, primarily because we're not going to examine all 500 companies in 1 year. We space it out a little at a time. But typically we do somewhere between 50 and 60 exams a year. So, the chances of getting selected, pretty high. And then if you're a big enough company, the multi-states can do what we call a multi-state exam. And so you could be part of that too. So it could be more than 50 to 60 exams in 1 year.
Good.
There was another question? Okay. All right, we are going to take a 5-minute break, so we're actually ahead of time. I thought more people would have questions. Okay, 5 minutes.